Good morning. Based on a review of the two trials in State versus Deedy, the related federal proceedings, and the case law, I have determined that the Honolulu Prosecutor's Office will not proceed with any further prosecution of Christopher Deedy. I have made this decision carefully after much thought. I drew on my 17 years as a prosecutor, but probably even more importantly, my 15 years as a circuit court judge. And it wasn't an easy decision, but the job of the prosecutor's office is to do justice, not win cases. And let me say at the start that I found Justice Nakayama's dissent in State versus Deedy to be very compelling. And at this stage, I'd like to draw your attention to State versus Moriwaki. This is the Supreme Court decision written by Chief Justice Richardson, which is what the trial courts use after one or more hung juries to decide whether to proceed or not. And as prosecutors who are trying to do justice, this serves as a good benchmark for us as well, as far as whether to proceed with a case or not. And what the Supreme Court held in State versus Moriwaki is that the court can dismiss a case after one or more mistrials or hung juries. And in this case, there were two. And when making the decision about whether to dismiss or not, the trial court's job is to balance the interests of the state against fundamental fairness to the defendant with the added ingredient of the orderly function of the criminal justice system. But even that statement in Moriwaki kind of infers that the state is always going to want to do one trial after another without end, and that is not the case. Our interest is in doing justice, not winning cases. And so the Supreme Court said there were 6 factors to consider in whether a case ought to be dismissed or whether it should proceed to another trial. The first of those is severity of the offense charged. This case started over 10 years ago as a murder case. In the hung jury 8-4 for acquittal in that case. In the second trial, the jury acquitted of murder and were hung on manslaughter and the other included offenses. The case then went over to the federal court, both the federal district court here in Honolulu and then to the Ninth Circuit Court of Appeals. They looked at what the trial court judge had said about manslaughter, about their not finding evidence for it, and they dismissed the manslaughter case. So the way the case stands right now is the included offenses that this office had said at the time there was no rational basis for are assault 1 and assault in the second degree. So to me, the severity of the offense charged right now should be balanced is assault. And assault is a Class C felony, but it's not murder and it's not manslaughter. So that factor weighs against a retrial. The next factor is the number of mistrials and the circumstances of the jury deliberations therein so far as is known. Because some of the time you know about that, some of the times you don't. And we're referring to what the count was by the jury. And in this case, there were 2 prior hung juries. The first was 8-4 for acquittal. The second was 7-5 for acquittal. Now, in my 36 years in the criminal justice system, I have never seen that before. Typically, hung juries are 11-1 for conviction or maybe 10-2 for conviction. That's the typical hung jury. But to have 2 juries consider the whole case, and they deliberated for 5.5 days in the first case, 6.5 days in the second. This wasn't a rush to judgment. They took their time and they thought it through. The state was trying to convict Mr. Deedy and trying to prove beyond a reasonable doubt that self-defense did not apply. They were unsuccessful in both times. So the jury spent time They had a thorough evaluation of it, and they, in both trials. And as Moriwaki, Chief Justice Richardson instructed, serious consideration ought to be given to dismissing an indictment with prejudice after a second hung jury mistrial. Trying for a third time to get all 12 jurors, to convict unanimously with a different jury is unlikely to result in a different outcome. So this factor also weighs against a retrial. The third factor, excuse me, the character of the prior trials in terms of length, complexity, and similarity of the evidence that was presented. The first trial took 23 days, the next trial took 16. Both were long, both were complex. In both cases, the evidence presented at the trial was virtually the same. That included witnesses called, surveillance footage, the defendant's testimony, and the state was arguing for conviction, the defense was arguing it was self-defense, and the state tried to disprove self-defense beyond a reasonable doubt and were unable to do that in both cases. So this third factor also weighs against a retrial. Likelihood of any substantial difference in a subsequent trial if that is allowed. Again, the evidence in the second trial was the same as the first trial, and the state has already argued that the evidence is likely to be the same in the third trial as in the second, as in the first. Even if the top two charges are eliminated, one is intentional conduct, one is reckless conduct, it's the same thing for assault 1 and assault 2. One is intentional conduct, one is reckless conduct. And given that the evidence in the third trial is likely to be the same, the overwhelming likely result is another hung jury. This factor speaks toward dismissal as well. Number 5 factor, the trial court's evaluation of relative case strength. So we have to look at what the trial judge said at the time. And she said there was sufficient evidence to convict the defendant and there was sufficient evidence to acquit the defendant. That does not sound to me like a strong case for the state. And in fact, again, the state has to convince 12 jurors beyond a reasonable doubt that the defendant is guilty. There has to be unanimity. And in the first trial, when it's 8-4 for acquittal, second trial 7-5 for acquittal, like I said, I've never seen that before. It's really going to would be hard to argue that the state has a strong case based on what the trial judge's assessment was. So this factor favors dismissal as well. And the 6th factor, finally, is the professional conduct and diligence of respective counsel, both prosecutor and defense, but in particular the prosecutor. And I think you'd be very hard-pressed to find anybody in the legal community who would say that either the prosecutor, Jan Fuda, or defense attorney, Tommy Otake, are not skilled, are not diligent, and are not well-respected in the community. What this factor is going toward is if you have a prosecutor who didn't do a good job, who wasn't up to it, then putting a new prosecutor in there might make a difference. But she may have been the most experienced prosecutor in this office. She handled both cases. This factor weighs against a retrial. So, based on, to me, what I look at this is this office has had 2 full chances to convict Christopher Deedy. They were unsuccessful. And as I said, the prosecutor's job is to convince all 12 jurors of guilt beyond a reasonable doubt. Here we have an 8-4 for acquittal, then a 7-5 for acquittal. And again, I've never seen this before. It may be there, but I have never seen this before. And after hearing the evidence in both cases with arguments by good attorneys on both sides, the prosecution and the defense, the state was unable to prevail in convicting Mr. Deedy in both the first case and the second. Now, the Supreme Court has outlined in Moriwaki the factors to be weighed and whether dismissal is appropriate or to go for another trial. And when I evaluate those factors, and balancing the merits of proceeding versus not proceeding, I think a dismissal of the charge at this point is warranted. So I've said all along, the mission of this prosecutor's office is to do justice, not win cases. And we are doing that here. Enough already. Right? And I'll be happy to take your questions. Yes?
Did you consult with the Elderts family in coming to this decision? And if so, how do you feel about it? If not, what message do you have to them?
I did speak to Mrs. Elderts and her son about it. They were unhappy with the outcome. I think they were hoping there would be another trial. I think they had questions about how the cases were handled, whether it was manslaughter or murder in the past. But I said, we're dealing with the assault now. This is what we have in front of you, and we don't think it's going to change. So, yeah.
The Deedy case set a lot of legal precedents, a lot of things that we do now in courts as a result of the Deedy case. Do you think this will change? I mean, are you saying that you're going to look at cases that result in mistrials differently? You're going to have, are you going to look at it differently, or are you going to base it on the Moriwaki case?
Well, this case seems pretty unique. I mean, the prosecutors always should, after, if there is a hung jury, look at what went good, what didn't, what was the count, can it be made better the second time, different ways to do it. Is there evidence that could be unearthed that might change it? And I think that would continue in the future. I don't see this case as having any more precedent. Each case has to be decided on its own merits, on the strengths and weaknesses of it. You know, whenever self-defense is involved, can we disprove that beyond a reasonable doubt? Yeah,
Is there any,
Manolo.
I don't know if there's anything in particular that in the evidence or that the defense brought up that made this case problematic for prosecution.
You're not aware of? Did you say?
Yeah. Was there anything really the strongest argument for the defense, I guess?
Yeah, well, I think when you have a disagreement with parties having been drinking, and it ends up with one party shooting another, you're gonna have to look at the facts and circumstances, and again, can the state disprove beyond a reasonable doubt that self-defense applied? And in looking at this, I don't think this case was out of the ordinary compared to a lot of other cases, except that you had a law enforcement officer involved. And it's just, when you have two sides to an altercation, people are going to look at it different ways. These are always difficult kind of cases to do. And I think the results of the first two trials kind of spoke to that. Yeah.
If manslaughter was still on the table, able to prosecute, would you feel differently about this?
No. And I thought it was, what the federal court did was finding that there was double jeopardy in this. And I think there was concerns that Justice Nakayama brought up, that switching legal theories, violates judicial estoppel. I didn't need to get there because of what I've talked about here, but I think it's a legitimate point that trying to say something's intentional and there's no rational basis for any of the lessers, including manslaughter, and then after the trial ends in a hung jury, turning around and trying to argue it's reckless and changing your approach is troublesome to me. But it's not. Whether manslaughter's here or not wouldn't change the fact that you had these two hung juries.
The focus for the first two trials, obviously, murder and manslaughter,
Yeah.
not assault. So you feel that the prosecutor's office couldn't get an assault conviction with the evidence?
The state of mind is the same. I mean, assault is intentional conduct like murder, assault one, assault in the second, reckless conduct is very much like manslaughter. So I think the evidence would be the same. I don't think the jurors, would make a decision on whether to acquit or convict on the fact that it's murder or the fact that it's assault. That's been my experience. They look at the evidence and decide, is somebody at fault or not? Yeah.
When the U.S. Supreme Court said they would not hear the case, your predecessor at the time said that he would pursue a third trial again on assault. Are you saying that you would have done anything differently than your predecessor's office?
Well, I am doing something differently. You know, if he had run and he had won, I guess this office would be doing a third trial, but that isn't the way it turned out. Yeah.
Because, this case involved a law enforcement officer, did you think that there were some inherent barriers or difficulties in convincing a jury?
Maybe somewhat. I think it's problematic when either of the parties has been drinking at all, regardless of how much. I mean, and somebody has a weapon, that's problematic. But I think jurors also, this is Hawaii. A lot of people, are related to somebody in law enforcement or are friends with somebody in law enforcement. So generally the jurors are likely, to give the benefit of the doubt to law enforcement. And it's a good thing that compared to a lot of places on the mainland, most people in our society approve of the police and they know they have a tough job, and generally they like police, they like law enforcement. So that's always going to be a part of it, that you just got to do the best you can when you're trying to present a case, but that is always going to be a factor. Yeah.
What about it's been 10 years, the age of the case, would that have hampered another trial with memory, witnesses, and those kinds of
I think that's always going to make another trial more difficult. But and that's always part of the calculus, but if we thought the case could be proven, like I said, the testimony of witnesses is going to be the same. They're already essentially locked into their testimony. When I was a deputy prosecutor here the first time, I did several cases for the third time. The murder of a police officer, David Ronk, by Clyde Pinero. Other prosecutors had done it before. I did it the third time, years later. So each witness had to review police statements, had to review grand jury testimony, and then had to review their testimony in the first two trials. So, they end up testifying as long as you've given them a chance to prepare and review, they're going to testify very similarly to the way they did before. And here there was surveillance footage, the defendant testified, the other witnesses testified. They'd have to review a lot of stuff, but they generally testify pretty consistently with what happened before. Yeah.
So 10 years, that's a lot of resources for your office. Can you describe how much was spent on this case and what a third case would be?
I guess you'd have to ask Mr. Kaneshiro that. But it's the kind of thing, you got to do what's right. And if you want to proceed with the prosecution, you put the resources necessary to do it. If you don't think, for something like what was murder or manslaughter, this kind of thing, if we thought it was the right thing to do and there could be a difference in the outcome, we'd be proceeding with the case, but we don't. Yeah, Paul?
Just kind of follow up on that, because you talked about the complexity, the length of the case, that it is a drain on resources, and you're just saying that it's not worth the effort that you would put into it to get an outcome?
No, I'm just saying the outcome would be the same as the first two. And if you believe in the case, you're going to put the resources necessary to put in. That would not stop us if we thought we could get a different outcome this time. And there are resources, but there are resources in every case. And if we decide the person did the case beyond a reasonable doubt and we had admissible evidence to prove that, we would proceed with the case. That's always going to be our mantra, right? That we're going to, if there's admissible evidence and we believe it can prove the case beyond a reasonable doubt, we're going to proceed forward, whether it's a big drain or not. We're never not going to do a case because there are a lot of resources. Yeah.
It's always said that though, but you never know what a jury is gonna do, right? So I'm sure for the Elderts family, that's what they're thinking. Is like, if there's a chance at all, why can't we do this? Your response to that?
That's certainly possible. You don't know what jurors are going to do, but like I said, I don't think I've ever seen a single case where the majority of jurors voted to acquit 2 times in a row. It may be out there. I have never run into it, and at some point, in any prosecution, the judge is going to dismiss the case after, whether it's after 2 trials, after 3 trials. And who knows, you know, that now that manslaughter is out, there may be another Moriwaki motion that would have been brought by the defense. We'll never know because we're not, you know, proceeding at this point. But the ground has shifted somewhat because of that.
Also,
Yeah.
the climate is a little different now versus 10 years ago in terms of public sentiment of, you know, police-involved shootings like
Mhm.
this. Do you think, did that factor in at all? Like that maybe a jury now would see things a little differently because of that?
Well, you may recall that relatively recently, this office tried to hold police officers accountable and had an extremely difficult time doing it. So the ground on that, the public sentiment may have shifted in some places on the mainland. I don't think it shifted here.
Did that case factor into?
No. Each case is on its own merits. In that case, we couldn't get up to the plate. Here they've had 2 complete, full trials. Okay, any last questions?
Yeah, other cases, we had a case last week, charges in the Kollin case. What's the status of your review?
Maybe I'll see you folks later this week. Okay, thank you all very much.